Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today, let us discuss a case relating to transfer of employees. So, Supreme Court held that the employees cannot insist to be posted or to be transferred to a particular place. It is the employer who has to decide and transfer them, not the employee. No doubt he can request for a transfer, but it may be considered or may not be considered by the employer. But the employee cannot pressurize, cannot insist for a particular posting. So this was decided while dismissing the appeal petition of Namrata Varma. You can see this case as Namrata Varma versus State of Uttar Pradesh 2021. You can find it in Live Law LL 2021 SC 444 444 page number. So it's a fancy number. Please, you cannot easily forget it. So while disposing the so-called SLP number 36717 by 2021 on 6/9/2021, Supreme Court, two judges bench, M.R. Shah and Anirudh Bose. So they held that Namrata Varma cannot be posted to a place where she worked for 13 years. That's another point. So now let us go into the details of the case. So the petitioner or writ petitioner, Srimati Namrata Varma, she is working as a professor in psychology in Rajakiya Mahavidyalay Amroha, that is in Uttar Pradesh. Right? Okay. So she worked there for 4 years. After 4 years, normally the government policy is to transfer the individual to some other place. As such, she has represented to be transferred to the so-called previous place, that is Noida, same postgrad college of Rajakiya Mahavidyalay, Noida. She wanted to get a transfer, but it was the representation dated 14/9/2017 was rejected by the higher authorities. So therefore, it was challenged before the Allahabad High Court. Of course, High Court also said that there is no point to interfere because employee cannot insist for the particular posting. So ultimately, she filed a special leave petition and approached the Honorable Supreme Court of India. So the point, affidavit filed by the other Rajakiya Mahavidyalay, it is clearly stated that she worked for 7 years in Noida branch from 18/12/2000 to 11/8/2013. So she worked there for about 13 years in Noida. So as such, it is not justified, 100% not justified. But normally, when you complete 4 years of term, normally you should get, this is a government policy, you should get a transfer. But I don't know why the education department or the concerned university, Rajakiya Vidyalaya people, they were keeping silent. Maybe no other faculty might have been available. So there may be so many reasons for a retention. But anyway, she stayed there, she worked there for 13 years. And once again, from 2017, 4 years only, she worked 2013 to 2017, she worked in particular Amroha. And now she wanted to get back to Noida. Maybe she may be having so many other interests also. But so previously already the High Court held no merit in her contention so to disturb the order because she was transferred to some other place. So definitely her petition has been rejected. Now the Supreme Court also held that the petitioner is not entitled to be posted at the place where she already worked for about 13 years. So she can request for some other place. It's okay. Definitely she may have some interest, she may ask it. But when the higher authorities rejected the same, definitely she has got some other option. That's why whenever we are going to transfer persons, normally we will be asking their options. 3 options we will ask them. So 3 options, definitely number 1, where he wanted to give education to his children, where he wanted to settle, or where he wishes to work. So all these points will be taken into consideration. But more than that, you cannot insist or you cannot put pressure on the higher officers that you should be transferred only to a particular place. Reasons may be so many. Definitely you may be having, your child might have been studying there, or you have to look after some other people. So many reasons are there. But still, the government has got the employer has got the authority to post you to any place it likes. Already much leverage was given to her in Noida. She worked there for 13 years. Why doesn't she go and work some other place? So this is the point Supreme Court has raised. Ultimately, to conclude, I want to tell you that as government officials, as professors, she is nothing rather than a professor in psychology. So please remember, the rules are there, CCA rules are there. You have to follow the rules. So once you work for 4 years, yes, definitely you have to get a transfer, but not the place where you previously worked. Why she has applied means, I know there are so many cases, there are so many persons who worked in a particular place for 20 years, just by bypassing these rules. So normally after 4 or 5 years they will be transferred to, from Ongole, they will transfer to Gedalur. Gedalur they will work for a year, once again come back to Ongole. Once again after 4 years they will be transferred to Markapur. 1 year come back. Like that, there are so many people who are staying at Ongole, who are not disturbing their families at Ongole. So we should not take them as good examples. They are bad examples. But anyway, Supreme Court has clearly stated that there is no point in interfering, and that ultimately, so it is the employer who has to give posting, not the employee who can insist. Good decision. Please follow it. Thank you.